Mr. Chairman, I'd just like to say to Professor Turley, the last time we had contact, I was a little brusque maybe with you, a little rough shoulders. You're a gentleman and a scholar, and I appreciate it, and I apologize if I went too far.
Thank you very much, Representative.
Mr. Massie.
You're welcome.
Thank you, Mr. Chairman. I'd like to associate myself with the comments from Mr. McClintock and Ms. Lofgren that any protections that we provide shouldn't be for a special privileged group of people. I mean, that's not the way the Constitution was written. Ms. Overlander referred to the press as the fourth estate, which prompted me to look up what are the other three estates. And it's a reference actually not to the three branches of government, but to the three estates in Europe, which were the clergy, the nobility, and the commoners. And I think all of them, including the fourth estate, deserve the protections of the Fourth Amendment. So whatever we draft, I hope it's not just particularly for Congress or for the media. Professor Turley, you touched on something that earlier, but didn't get to spend enough time on it, I think, about the third-party doctrine. And can you explain to us in a little more detail how that came about and what we could do in Congress to sort of rein that back in?
Yeah, quite frankly, I think the Supreme Court has made an utter mess of this area. And I think even people like the late Justice Scalia made reference to the fact that constitutional criminal procedure, which I used to teach, was just an absolute morass created by the Supreme Court. And part of the problem is this idea of third parties, that if you give things to third parties, you don't have that same expectation. They treat things like pen registers, giving phone numbers, almost as equivalent of like Greenwood, of putting your trash on the curb, that you give up all expectations of privacy because you're giving it to someone that you don't know. Of course, when people put in phone numbers, they're giving it to a computer that they assume is subject to some types of regulation. But that has gradually expanded, where the exceptions are now the rule. So you have, with cases like Smith v. Maryland, a lower standard than probable cause under the warrant clause. And what you have to understand is every time the court creates one of these exceptions, prosecutors pour into the gap. And it's not because they are little petty tyrants, it's because they have a lot of cases and they believe very strongly in getting information. They want to get it fast. That's why you've had this massive increase in national security letters, because it's so much easier. You virtually have to show nothing. So it's going to be up to the Congress to make that path a little more difficult, to require showings. But the most important thing is to have some adversarial process and standing so that people like us can come and challenge these things. I do classified work in the national security area, and I'm read into programs so that the judge and the cleared prosecutor and I can argue about evidence. Those are the most extreme possible cases you can imagine. Some of those cases are really classified at the highest level. This should not be so difficult, because this is not highly classified information in the vast majority of these cases. What I think you heard from Mr. Berg is very important. I mean, his company is getting 3,500 requests a year.
Shouldn't the analogy, instead of taking your trash out to the corner and leaving it there and treating your data that way, shouldn't it be more like a safe deposit box? If I put something in the cloud, I have an expectation that you're going to do your best effort to keep it private. Yet we've turned the third-party doctrine, which we somehow are still cling to, has turned that on its head. And I hope we do take that on. I'm going to throw out a couple ideas here. If we were really, really, really serious, we would pass a law that has criminal penalties for those who invade your privacy at the DOJ, FBI, and NSA. And I don't care if it's just a $50 fine, and 30 days paid leave, whatever it is. If there was some crime associated with doing this, now the penalty should be much stiffer than that, obviously. So that's one thing I think we would do. The other thing I think we could do is to legalize technical solutions to privacy. Like, it's technically illegal to make a phone call from a location that can't be determined by the government to a location that can't be determined by the government. Why is that? It's technically illegal to have encryption that the government doesn't have a key to. Why is that? Why are we outlawing the technical solutions to this problem? I mean, we're afraid of privacy, but we're clinging to this notion that we can give all the keys to these things to some folks and not supervise them and trust that they won't be rifling through our stuff. So those are just a couple of suggestions. And Mr. Byrd, I like your suggestion of making sure that all of the national security letters or the secret requests are eventually, not indefinitely, kept secret, but eventually we know about those, because that's just critical. We got to know what we're trying to legislate. Thank you. I yield back.
Gentleman yields back.